Welcome back to Nationwide this morning, and we're now in the segment All Things Real Estate. And this morning in All Things Real Estate, we're focusing on how to properly manage land and property. So this is one you'll want to pay keen attention to as well. On today's episode, as I said, All Things Real Estate, we're being joined by the Managing Director of Law Boss Attorney at Law, Sophia Bryan. And Sophia will be offering expert legal insights into the proper management of land and property, particularly in areas such as inheritance, family land, and land disputes. Welcome, Sophia.
Hi, thank you for having me.
Thank you so much for being here on Nationwide this morning for All Things Real Estate. So today, Sophia, I will be presenting some scenarios, and I'd like you to walk us through how each should be handled from a legal standpoint. So the first one, as we set off here, common assault, the family land tangle. So let's start here. My grandfather leaves land for all of his children, but there's no will, and now everybody wants a piece of the land. What happens in a case like that?
All right, so we utilize the intestacy laws. So once somebody has some land and they have children that it needs to be passed on to, there's something called letters of administration or a grant of administration that has to be applied for. So typically when there's a lot of children in a family, there is one or two that assumes the leadership role, typically the oldest person, or maybe not the oldest, but perhaps the most educated person takes on that role. Mm-hmm. So if a family like that comes to me, I encourage them to actually decide who they want to be that individual to represent the entire family, and then we go through the process of applying for the letters of administration.
Mm-hmm. So that's where it all starts. Letters of administration.
Yeah, they have.
So that's where it starts and ends?
No. That's the first part of what I tell my clients. It's like a 3-part process. So we go to the court, we iron out the affairs with the court, get the grant, and then the estate has to apply for a TRN. The estate has to pay the relevant duties. And then hopefully at the end of that process,
when you said duties, what do you mean, like back taxes and those
back
things?
taxes and estate taxes, and that has to be paid before any transfer can take place. Mm-hmm. And then hopefully by the time we get to the part of paying the taxes, everyone is in agreement that the same the administrator that they've all chosen is the person that will go through the process of transferring the relevant shares to each person who is a beneficiary.
Okay. And that's where the matter ends if there's no other issue that comes up.
Well, if it has to be sold, then they have to come to an agreement as to who the buyer is, the relevant purchase price. So it's a multi-tiered process, and that's why I tell person, if don't leave it up to the children to figure it out. It would have been easier if there was a will or there was some kind of trust document in place to say these are the actual owners, this is how I want the property to be treated with, rather than having to go through the process of selecting among the children who should be the administrator for the estate.
Right. Here's scenario number 2 now, Sophia. Fast selling without proper documents. Mm-hmm. What if someone inherits a house and wants to sell right away to pay off debts, but the proper documents don't exist?
All right. So again, a very common scenario in our jurisdiction. So if it's a case where we know that this person is a rightful heir by virtue of a will, they still have to go through the process of whether it's going through probate or seeking letters of administration. You don't have the authority to do anything with the land until you've gone through that process, because the original owner who has passed, their name is on the title. Mm-hmm. And so you have to go through the process of assigning or changing that ownership. And so no well-thinking buyer in the market who has done their due diligence is going to give you any money until you can show a good title. So somebody who's inherited property without their name being on the title, they don't have a good title to bring to the market. So it's not right to accept money or to give the person money in a case like that, because you won't have any protection.
Right. So you have to get your name on title before selling.
Yes, that process has to be completed before any sale can take place.
All right. Scenario number 3. the absent beneficiary holding up the sale. Now imagine several siblings are ready to sell a piece of inherited land, but one brother who migrated 20 years ago is unresponsive. Can't hear from him. You call, no answer. How does the law deal with an absent beneficiary?
So, in our jurisdiction, or whenever I have consultations with clients and somebody lives overseas, the rhetoric is like, oh, this person has been away for so many years, they don't care, they don't want anything. And then, as soon as they hear that a conversation has been had with an attorney, all of a sudden there's this desire to either return home or a desire to have a say in the transaction. And so sometimes if they don't feel included in the process, that's when they go ghost. But the good thing is when you are going through the administration process, even if there are several heirs, one person can assume the responsibility. And as long as the proper protocol was followed to give everybody notice, presuming that you know where the individual lives, as long as everybody is served notice that Mary Brown is the one that's applying to be the administrator for the estate, you satisfy the legal requirements there. So if they don't want to respond, if they don't want to come into play, that's fine. The challenge, though, is if they were a part of the process initially, and maybe they're upset about how things are going and then they disappear, then we would have to seek permission from the court to intervene or seek guidance from the court from time to time. But usually if they're served notice, they know about the process, that usually suffices.
Okay. Scenario number 4 now, unregistered land. We want to sell, but the land has no title. Let's address this one.
All right.
A family wants to
Yes.
sell ancestral land, but the title was never registered. Only an outdated common law deed exists. What are the complications here?
So when there's a common law deed, that family is probably in a better position than 90% of the individuals that have unregistered land in Jamaica. So you have to go through the process of applying for first registration with the National Land Agency. So there is that's a multi-step process as well. They have to get the property surveyed, and we have to get a pre-check plan. What a pre-check plan is something that's presented to the government of Jamaica to say, based on our knowledge of the land, these are the actual boundaries, and we're asking for you to approve this. Once that approval has taken place and the government is satisfied with the boundaries that the family has identified, they have to find individuals in the community that have been there for many, many years to say, oh, we know that that family has been living on the property for well over 2-3 decades, and we can attest to that fact. And then an application is submitted. Again, there are costs associated with this process. And so it's important to ensure that you get proper legal advice. The persons who are giving evidence to say that they know that the family is the true owner, they have to meet certain age requirements, and they also have to demonstrate that they are of sound mind. Right, so it's definitely possible, but it's a process that you'd have to go through to get the new title.
Okay. And speaking of titles, Sophia, someone, Shirley Augustine, is asking, how long does it take to get a land title?
All right, so remember I spoke about the survey process, and it's an approval process. So sometimes that can take 6 months to a year, and that's just the first part. Right? And so hopefully during that process, all the individuals that you've asked to give affidavit evidence that you're the true owner, those people are still alive by the time that process is finished. And then we prepare all the necessary applications and present them to the government, and then the relevant assessment is done for property taxes. So it's a long commitment. That's the point. And so if you wanted it, it's something you probably should have started like a year ago. So I say commit to a 2-year process. It can possibly be finished sooner. Sometimes there's a backlog in the system with survey diagrams being reviewed, and sometimes there's a lot more efficiency. So, but I would say a 2-year period is a reasonable timeline so that you don't get stressed out while the process is taking place.
And OMS Associates is asking, please ask if all the beneficiaries can change or reorganize the will.
No, that sounds like fraud. That sounds like something illegal.
Right.
No. All right, so segueing into will. So there's certain requirements, legal requirements under Jamaican laws for a will to be satisfied. I said to persons, the will doesn't need to be signed by a justice of the peace or a notary public in Jamaican law, but you do need two witnesses. And both witnesses have to sign off at the same time. So, for example, if I prepare a will for an individual, I get somebody from my office to be the witnesses. We call them in, come review your document. If you're happy with it, sign, and then the two witnesses will sign right after the owner of the estate signs off. So we typically keep a copy for about 6 or so years as a requirement, or even longer in some instances. But the will cannot be manipulated. If it's manipulated, then you can go through different companies that go and verify if the document is real or fake.
The questions are coming in. We don't have a lot of time, but see if I can squeeze in one more,
Sure.
Sophia. Tyrell Thompson is asking, what if the estate is left for 8 children?
Yes.
And a child of one of the siblings wants to build, and one of the 8 opposed? What then?
Well,
So you have 8 children. One of them has a child. That child is grown now, wants to
Yes.
build on the land, but the other siblings say no, opposes that. What happens in a case like that?
Well, I would say, that individual would be like second generation, and I would say proceed with caution. So until the necessary administrative processes are gone through to say, okay, these 8 children are actually the beneficiaries, and you're acting under one of the beneficiaries' ownership, until that process is completed, I would say proceed with caution. The challenge with administration is that it can be an expensive process, especially if there's no desire to sell the land. But the government of Jamaica does offer support to persons that may not have the means through the Administrator General's department. And so if you can reach out to that agency for support, but if you want your process to move on, obviously it makes sense to reach out to an attorney. But proceed with caution. Don't do anything until there's a title in hand to show that you are actually acting under a beneficiary.
If someone is living on a piece of land for over 30 years, can they get it to buy?
So in order for some kind of transaction to take place of buying and selling, there needs to be a vendor and a purchaser. So you need to identify who the vendor is. If you've been living there for a number of years and you can't identify a vendor, there are different ways that you can explore. Reach out to the government of Jamaica. Sometimes that land may actually be owned by the government. So don't assume that because you don't see anybody popping up for that number of years, there's no owner, there's no rightful heir to the land. That doesn't exist. So you'd have to do the proper due diligence checks, and that's something that we can assist with because we have access to the relevant databases to search for owners of property and advise there.
Yeah, we could go on all morning, Sophia.
Yeah.
But as I wrap, next week your law firm is hosting an asset protection and estate planning webinar.
Yes, we are.
Tell us a bit about it and how interested persons can sign up.
Right. So we are going to be talking about if any of these scenarios caused you to pause. We're going to be dealing with these type of scenarios, what documentations you need to put in place to protect your assets, and especially new legislation that covers trusts. So a lot of persons don't know that Jamaica has trust laws, and so I'm going to be talking to persons about that and sharing the relevant guidance there. Encouraging you all to follow my YouTube channel. It's The Law Boss Firm. The Law Boss Firm. Follow the YouTube channel. I'm going to be sharing educational content there. Send me a WhatsApp, 990-7313. That's 990-7313, and I will send you the link for you to register for the webinar.
Sophia Bryan, attorney at law, managing attorney at Law Boss Attorneys at Law, talking to us this morning about how to properly manage land and property. This has been the segment, All Things Real Estate. Thank you so much, Sophia.
It's a pleasure. Bye.